My lord, I beg to mention item number 2 on behalf of PK Dasman. My lord, in this matter, paper book has been received, but conducting counsels there from Guwahati today.
Fix it for hearing
Yes, my lord. On 16th of this month.
on 16th.
Yes, my lord.
Okay, we'll fix. Let the list start. Yes.
This item number 2 and 3.
Yes.
Analogous.
2 and 3 together, na? It is submitted that matter is ready as regards paper book and record, and copy of the paper book has also been submitted, furnished to the learned councils. First of accordingly, release this matter for hearing on
16th, my lord.
16th of
August this month. Okay. And
not possible Friday. Friday not possible. Even next date. When then?
I'm not sure any other date, my lord. After that, my lord.
Okay, 22nd.
22nd. Much obliged.
Okay.
Mayor, your lordship.
Hard. Yes.
For respondent 1 and 2, minutes.
We'll admit this appeal. Hard Spencer, learned counsel for the appellant. Also hard Ms. Spencer for respondent number
1 and 2.
one. Only one respondent?
No, your lordship.
There's
4
five
respondents are there.
Who are the other respondents?
3, respondent number 3 is represented by SK Diori,
SC,
SK Diori,
SK Deori.
and respondent number 4 has not yet entered appearance till date, your lordship.
Admit this appeal. This is an appeal against this is an appeal against intra-court appeal. This is an intra-court appeal against judgment and order dated. Judgment and order dated, there is no date.
31st August
31/8/2023. Passed in WPC 342 of 2022. First up, by the impugn judgment, a direction was issued to the appellant APPSC to to correct a certain answer keys. Question number 18 and 19, 6 of the answer key. First of, admit this appeal. Issue notice returnable after 6 weeks. First of, considering the fact that a direction was issued for correction of answer key to the question number 18 and 19, 96 of the question of the examination in question, which may of the petition in respect of the appellant respondent number
3, your lordship.
3 only, which shall have a consequential effect on result of the entire election, and that the other selected candidates were not parties, comma, the impugn judgment that is stayed
Obliged.
until further orders.
Your lordship, item number 5 is also same, your lordship.
Item number,
5, your lordship.
then why this has been listed in the orders?
Your lordship,
Item 5, item 5.
here, your lordship, inadvertently, respondent number 5 and 6, who were the private respondents in writ petitions, were not met as a party.
Then
So by filing IA, these 2 respondents were impleted, your lordship.
already
Impleted.
okay. Huh? Steps for service in okay. Now we'll take the first steps. Same order.
Obliged.
But you take issue notice returned from petitioner to take steps for issuance of notice upon the answered respondents.
Obliged.
Also, we have received a paper book lawsuit.
Item number
4.
For lawsuit.
yes.
My
But it's
lord, I have
better-
received a paper book yesterday. I am for the appellant.
Okay,
And my lord, one thing, so far, waiting of the respondent number 2.
Uh.
This IA has not been taken up. Therefore, my lord, my prayer at this stage, the registry may be directed to appoint the amicus curiae on behalf of the respondent number 2, who is the informant in this case.
what is the matter here?
Matter pertaining to
Three-
307.
302.
Why necessary? Not necessary. In spite of service of notice upon respondent number 2, nobody has entered appearance. Full stop. In view of this, in view of such fact, the appeal shall proceed ex parte against respondent number 2. Full stop. Accordingly, list is better for hearing
After 2 weeks.
after 2 weeks.
Alright.
Right.
Lordship, this matter may be adjourned, Lordship, the page number, page number 30, this.
Page number?
Yes. Matter may be adjourned.
Adjourn.
Yes, after 2 weeks, maybe
Oh,
fixed after 2 weeks.
On the prayer of the learned counsel for the appellant, list this matter after 2 weeks.
2 weeks. List is over.
23 to
27, your lordship.
27 or 29? 27.
27, your lordship.
27, okay.
After 2 weeks,
After
2 weeks, your lordship.
weeks, as agreed with the learned counsel for the parties, list this matter after 2 weeks.
And also, your lordship, item number 10 and 11, your lordship. This matter may be listed after a week, your lordship.
10 and 11, okay.
Yes, your lordship.
After a week.
And also, your lordship, item number,
These matters in the week commencing from 19th of, as agreed to by the learned counsel for the parties, list this matter from the weeks commencing from 19th of August. Yes,
and also your item number 32, your lordship, supply hearing. This matter may be listed after a week.
My lord, I have a
6:32.
32. Okay.
Uh,
After?
After a week, your lordship.
After.
16, my lord. 16 I'm the petitioner, my lord.
Huh?
16, 32,
Item number?
32.
32, you are the petitioner.
16, my lord.
Sunil. No.
Maybe fix on 16, my lord.
This 16 will not be possible. This will be a last date.
Okay.
Do not want to carry a bag to Guwahati.
It can be disposed of. It is a simple matter, my lord.
Such Friday, do you want to?
Okay, then.
Not that simple, Mali, and let me speak.
Okay, my lord.
Yes,
And also, your lordship, item number 30, your lordship.
30.
This, I'm on, after a week, your lordship.
Huh?
After a week,
I have objection, my lord. My lord, this,
After?
after a week, your lordship. In this matter, your lordship, our AAG, Additional Advocate General, sorry, Senior Senior Advocate G8 is appearing. Today is not present today, so he instructed me to adjourn this matter, your lordship.
my lord, this matter is pending since 2018, my lord. This is service matter, my lord. No selection of the petitioner, my lord. My lord, may kindly take up this matter. And my lord, there is private respondent, my lord. He'll take care of,
No,
Their
no,
side also.
that argument will not accept. Because it is the action of the state. Private respondent is the
my
beneficiary.
lord, they have filed their affidavit, my lord. It is.
When can
on
he,
record.
when will be he ready?
Next week, your lordship.
And let us take next week.
My lord can understand, my lord. The counsel, my lord, for the petitioner is such a matter, my lord, they are, how they are screwed by the client, my lord.
No,
This
no,
is
we know.
pending since
So
2018,
since
my
a
lord.
personal difficulty is expressed,
Yes,
we'll fix it on Monday or Tuesday.
yes, your lordship.
Yes, my lord.
Yes, sir.
Huh?
Monday or Tuesday.
Monday or Tuesday, give a date as per his convenience.
Yes, your lordship. And
Tuesday?
Tuesday, your lordship.
Tuesday.
My lord.
Oblige, your lordship.
Your Lordship, I beg to mention unlisted matter for today.
Unlisted, what is the urgency?
Actually, the impugn order issued is executing tomorrow. So if
What is the, what is here? What is the executive order?
it is Lok Adalat impugn order.
It's a settled order, compromise order.
It is in order it's mentioned, but it is not compromised because the petitioner was not there during the hearing.
Okay.
My lord, I beg.
But see, list is almost collapsed. Will it be possible to bring before we rise?
Actually, we are not going through the facts of the case, but the order of the this.
No, have you filed this petition only? How much time will you require to bring it from the filing section to here?
Oh, it's already there. It's already there. in
Okay,
file.
because almost all matters are adjourned.
Yes, Your Lordship, it will be.
Yes,
My lord, I beg to mention item number 12 to 15, my lord. Here,
See.
my lord, my lord, we required to file affidavit, but Parava is comment that we have to receive, my lord. I've taken consent of the other party, my lord.
Okay. As a termination.
My lord,
Termination. There is no stay order.
My
So
lord.
they are having an anxiety.
my lord, that's I understand. my-
Yes.
Likewise, my lord,
According to you, these are the illegal appointments.
Right.
That's why terminated. And on the basis of a Supreme
Yes.
Court judgment, stay was not granted.
290
Anyway,
cases there.
on the prayer of the learned council, for the standing council education, matter stands adjourned.
After 3 weeks, my lord, maybe.
At least
3 weeks.
this matter after 3 weeks. Full stop.
Deeply applied.
May I please, madam?
Yes.
I beg to mention item number 19 to 22. My senior is out of station.
19 to 22.
Yes. So this matter will be fixed after 2 weeks, madam.
After
2 weeks.
consent, you have taken consent?
yes,
Yes. After 2 weeks, as agreed to by the learned council for the
Yes.
parties. Yes.
May I, Your Lordship? Though, Your Lordship, I beg to mention item number 31 as well, Your Lordship.
Item number?
31, Your Lordship. I have taken the consent from.
So hearing is over.
Your
Item
Lordship.
31, 2 weeks.
After a week, Your Lordship.
After 2 weeks. Next week, we have fixed so many matters for hearing in the part 1 list. We are having only practically 3 working days. So we are not, we do not think that we will be able to complete this hearing matters. That's why.
Oblige, Your Lordship.
May I please, my lord? My lord, this is an urgent transfer matter, my lord.
Unlisted.
My lord.
Oblige. So whole list is collapsed. Except item number 18. Okay. Item 1. Yes,
Your Lordship, I would like to withdraw this matter.
okay. Learned counsel for the petitioner submits that she may be allowed to withdraw this petition in view of
With liberty to.
what liberty? In view of the challenge to the order dated. Yes, which for the other side, some standing counsel made such withdraw with a liberty to file a fresh prayer is allowed. Accordingly, contempt petition stands dismissed on withdrawal with liberty.
Much obliged.
বাকি order তো লিখো লিখে dispose ঠিক আছে
My Lordship,
yes
Lordship, leading counsel is out of station on medical ground.
Hmm.
So this matter may be fixed after 1 week. In this
what
case,
about interim order
interim order, Your Lordship, the respondent, they will reply whether the police station they have acquired land allotment or not. So I have no further submission. This leading counsel is,
similar order we have fixed what some orders are there
yes, yesterday, one Nabum Kaya, there's the same case.
when it is listed
It is listed on next week, Wednesday.
okay list this matter along with WPC
Yes, yes.
item number
This 226 today.
no that petition order fixed in the on Wednesday
That I propose. I didn't propose this
no what is the item number yesterday's
yesterday.
you give the number we'll fix along with that item
Yes, yes.
Mr. Ratan was there
Yes, yesterday.
Yesterday.
Yes.
He was there
Yes, sir.
and he produced that there are some.
Yes, similar matter, your
Ah,
lordship.
when
Yes.
it was fixed on Wednesday.
On 14, your lordship. to
What is
file
the,
affidavit.
what is the case number?
Case number is 215, your lordship. Nabam Kaya.
Is this matter along with WPC 215 of
Yes.
2024
14-8.
14/8/2020 interim order pass earlier shall continue till that.
My
Yes, you have not corrected the cost title.
Yeah, yes, I have done.
Oh, you have not.
Done.
Where is it? There is a report that you have not. The learned counsel for the petitioner has not yet filed corrected cause list directed with the school.
I have already submitted the registry.
When? Okay.
On same day. When matter was listed.
Submitted before whom?
At the registry that in the office of.
Yes, but report says something different, 8/8.
I'm sorry, Your Honor.
Huh?
On same day, I have corrected and I have
You have
submitted.
furnished the amended quota is cost title.
That one I have submitted at the office of Bakara, where we have done registration.
Office of? Just
Advocate
verify.
clerk. Advocate clerk.
There is no reflection in the cost title.
Then Your Honor, I may be given then some more time.
It is submitted by. It is submitted by learned counsel for the petitioner that in terms of this court's order dated 8/8/2024, the learned counsel for the petitioner has already filed corrected cost title before.
To advocate clerk, my lord.
Huh?
He has submitted to the advocate clerk.
No, you'll have to submit in the. So then we'll record that in view of office note dated 8/8/2024, learned counsel submits that he will furnish the corrected cost title before the registry by today itself. Accordingly, list this matter on Monday if the corrected cost title
Your Lordship, on Wednesday.
on Wednesday, that's all.
Highly obliged.
Please.
4 and 5.
4 and 5.
Yes, what is your instruction?
My lord,
Yes.
it
Yes,
is.
sir.
My lord, as per the instruction, my lord, it is done as the appointments done as per the 9th executive committee meeting, my lord. Mr. Raja Seva. And
No, will not accept this. Hard. Learned counsel for the petitioner. The petitioner who claims to be the head teacher of GPS Mapsoro. No, the petitioner who is a head, like the earlier order, huh? The petitioner who is a head teacher at GPS Mapsoro claims for the vacant post of CRCC. Accordingly, according to the petitioner, he had applied for the said post and the respondent number 5 had also applied for such posts. However, ignoring the seniority of the petitioner, the respondent number 5, who is senior to the petitioner and who has joined the service of teacher only in the year 2023, has been appointed to the post in question. In the aforesaid backdrop, and taking note of similar disputes pending in this court, directed the state state authorities to obtain instruction to the following effect. WPC 311, pencil mark to pencil mark. Written instruction has been received. In terms of the instruction, what is discernible is that in the ninth executive committee meeting of SSA Rajya Mission Society held on 22nd of November 2001, it was decided to appoint BRC/CRC district coordinator for different interventions from teachers with sound academic background with 10 years of experience as JT with B.Ed, B/BLed, and the DPD/DPOs would be the appointing authority at a district level on approval of the executive EC.
Chairman of the executive.
Okay, forget about that. Full stop. It is also discernible that there is no guideline rules for appointment. However, the criteria for appointment, no guideline for appointment. It is also stand that as Samagra Shiksha is a registered society, there is no question for advertisement. Full stop. Such stand prima facie cannot be approved in exercise of a power. It cannot be approved for more than one reason. Full stop. The scheme of Samagra Shiksha is a sponsored scheme of which a major portion is financed by the Union of India.
Well, just
Yes.
like to clarify one regarding this matter. I made telephonically query even after receipt. They said if suppose there's more than one candidate, in that case, what happened? They used to constitute a committee and committee take interview on the basis of interview.
Interview on basis of what?
My lord, overall criteria that is
No.
my lord.
Overall, will you call all the qualified person for interview?
My lord, not
Somebody may not be interested.
My lord.
Somebody may be interested. Whom will you call?
only person who interested.
How
Suppose-
do you know they're interested? How
Whether-
do you know that they are interested? You will have to
My
not
lord, that-
show.
I duly accept, my lord. That's fine.
You will have not to say that this is the CRCT vacant. Please,
My lord.
who are interested, please come
Right,
forward.
my lord, my lord.
Such course, okay? By the Union of financed by major portion is financed by Union of India.
It's a financed by the government of India.
Financed by the government of India. Full stop. The role of BRCCs, CRCCs are to coordinate with the teachers for proper implementation of Samagra ISSE. And therefore, the BRCCs, CRCCs shall have a vital role in proper implementation of such policy and scheme of the government. Full stop. In the aforesaid backdrop, when a qualification is laid down to be minimum 10 years experience with B.Ed, B.Led, there will be many persons having such qualification, and they might also be interested for appointment of performing such duties. And therefore, the procedure opted by the state that is pick and choose policy cannot be approved for such important position which is having direct link with imparting education, more particularly primary education. Therefore, this matter needs, in the considered opinion of this court, this matter needs further consideration. Accordingly, let a notice be issued returnable after 4 weeks, full stop. Considering the matter in entirety, the impugned appointment of the respondent number 5 stands suspended, full stop. The post of BRCC, however, the respondent shall be at liberty to fill up the post of BRCC CRCC by seeking application from competent and eligible persons under the cluster or the block, as the case may be. We are not stalling everything.
My lord.
This is the procedure.
My lord,
They might say this is their resolution.
my lord.
You have the original guideline of the Sarva Shiksha. Clearly it is given without advertisement, there cannot be anything.
Well, in case of item number 5,
Ah.
the applicant petitioner is for BRCC. That is
Same
also
order.
Same
Same order. One is BRCC, one is CRCC, 4 and 5.
of
Yes.
Yes, my lord, here regarding the transfer posting, my lord. The petitioner, he has been posted from the post of BRCC, he is holding charge of BRCC to GUPS Anchorman. So my lord has rightfully posed some question on the previous occasion regarding my appointment as a BRCC. So my lord, at the time of my appointment, I was already serving more than 10 years as previously item number 4 and 5.
No, that is, we are not questioning your eligibility so far relating to appointment of BRCC.
Yes.
Now, are you having any right to continue as BRCC? Where is your appointment order
Mine,
as a BRCC?
present appointment order. Right now, my lord, I am challenging my transfer. My
No,
lord.
understand.
Yes.
You will have to show that I have a right to continue as BRCC. You have been transferred to your original place of posting,
Yes.
which you substantially hold. That is your substantive post. When you are transferred to substantive post, it is not as such a transfer order. It is an order releasing you from your additional duty. Now you tell us on the basis of your appointment of BRCC that you are having a right.
Yes, my
That is
lord.
the vital issue.
My lord, whenever
If you can say that I have a tenure of appointment, this, I cannot be transferred, repatriated to my parent posting, then of course will stay. And if you don't have any right, how can we stop it? In the exigencies of service, they may think that you are required in the school, will have some other says BRCC. Maybe.
my lord, according to the petitioner, my lord, and as per the transfer order posting pertaining to the education department, whenever a transfer has to be made, they should be in the larger interest of the student, my lord, for the general.
That we cannot decide.
Yes, my lord, but here I have been, my lord, serving as BRCC, which is a substantive administrative post for last more than 10 years, my lord.
So do you say after few days that no, now I forgot how to teach?
No.
Therefore, keep me as BRCC for all life to come.
Immediately after.
BRCC
Yes, my
is not your substantive post.
Yes.
It is a functioning additional thing which is a creation of a under scheme. You will have to understand the fundamental of service jurisprudence. Your substantive post is a teacher. They think that you should go back to the. They have passed this order.
My lord, I'm just praying on medical ground also, my lord. Recently, I underwent surgery, my lord. And because of that.
Surgery
Yes.
went in the year 2000 something.
My lord, actually, I was not in documents at the time, but I could procure it.
Don't procure.
No, my lord.
Procure is very
I
difficult.
received the instruction, my lord.
Don't procure.
Yes, my lord.
Medical document moment you see I have procured.
It was already attached, but I could not at the time, we had a different discussion, so I was not able to produce it, my lord. So,
It was done in the month of April.
yes, my lord, only
But-
2-3 months ago. And if you, my lord may come to,
Heard
yes, my lord.
the learned counsel for the Mr. B. Swensu, learned counsel for the petitioner, also heard Swensu, the learned standing counsel for the education deputy. The present application is filed by the petitioner assailing the order of transfer dated 31/7/2024, challenging his transfer as BRCC to Puchi Zeko or BRCC PUCHI GEK to GUPS Hanka. Full stop. The fundamental ground of such challenge are that a transfer order has been issued for reason of the petitioner to travel to such a distant posting is said to be difficulty in walking due to his multiple fracture in legs and the repair thereof conducted in the month of April 2024. Full stop. The learned counsel for the education department submits that the transfer order is issued in public interest, and it is a common order whereby different persons were transferred. It's a regular transfer order. Petitioner's appointment as BRCC is not his substantive post, and therefore the same cannot be termed as transfer in as much as he is put back to his substantive post. Full stop. At this stage, the learned counsel for the petitioner submits that his employer, being a model employer, should examine his prayer for staying the transfer order for the reason of his health condition. Full stop. Accordingly, he submits that the respondents full stop. In view of the aforesaid, this court is of the also that employer should consider the same in accordance with law. Full stop. In view of the aforesaid, the present transfer petition is disposed of at the motion stage, directing the respondent number. Who will decide? Director.
Yes, yes, my lord.
Director. Education.
Education.
Director of the education department. That is respondent number.
Respondent number 3, my lord.
Respondent number 3 to consider the case of the petitioner. Full stop. The petitioner is permitted to file a fresh representation before the director within a period of 1 week from today. Yes, fine. 1 week from today. And if such representation is filed within 1 week from today, the director shall consider the same in accordance with law. In accordance with law and in accordance with law. Full stop. Till such according to law, and such decision be taken within 2 weeks from from receipt of a representation to be filed by the petitioner. Full stop. Full stop. Till such representation is disposed of, it is provided that the status quo as regard posting of the petitioner as on date, as on 7/8/2024 shall be amended.
Deeply obliged.
My lord, the respondent number 3 is Deputy Director School Education. my lord.
Who will consider his case? Director.
It should be a Director Elementary Education, but they
Director-
have not made as a party here.
But we'll say Director Elementary.
Elementary Education.
Director Elementary Education, huh?
Right.
Yes.
Deeply obliged.
Yes.
My lord,
Why you say that it has been issued without authority?
my lord, kindly come to Page number 36, my lord.
Page 36.
Oh, I'm sorry, my lord, page 36.
What is your instruction? Page 36.
I'm
Yes,
sorry, page 38, my lord.
page 38.
Yes, ma'am. Clause 7. my lord. This is regarding, my lord, policy, my lord. Teacher transfer and policy 2019-2020.
Yes.
11, my lord, authority competent to effect transfer. In order to effect transfer and posting of teachers or an education department, the Secretary Education Department shall be competent to exercise all power under this policy.
Just a minute.
My lord.
Yes.
Yes, madam. As per this clause 11, madam.
That power is given to the
Secretary Education to effect the transfer. Before that, my lord, there is process, regarding transfer and posting of the teachers in education department, which is, my lord, governed by, my lord, this Honorable Pradesh Education Rules 2010.
Where is that?
My lord, it's start from page 19, my lord.
Page?
Page 19. Relevance will be, my lord, start from page 22, my lord. Relevance, page 22. My lord, the rule 51. my lord.
Rule 51.
Yes, ma'am.
Yes.
Steps in transfer and posting process of teachers. My lord, Roman 1, my lord, the deputy director of school education of each concerned district will classify the school location under third, middle, and fourth.
So let us do one thing.
Yes, ma'am.
Let this, your transfer order has been passed by whom?
Deputy director, school education. ma'am.
Then who is, according to you, who is the authority? 11?
My lord,
Secretary.
my lord, it should be approved by, my lord, secretary. ma'am.
Now, how do you say that this is not approved?
My lord, kindly come to, my lord, the page number 45. ma'am. My lord, before that, my lord, as I'll take Joseph to Annexure 6, page 44, my lord. My lord, without authority, my lord, the deputy director of school education of Longling district, my lord, he is proposes, my lord. He started a process to mass transfer of the teachers under the Longling district, my lord, without approval from the competent authority, my lord. That is at
Which page?
Page 44, man.
Page 24.
44, man. 44.
Yes.
My lord, this is the, my lord, list of teachers, man. This deputy
Page
director.
24.
44, man.
Page 44.
Yes, ma'am.
Just a minute. Yes.
Page 40, man. This is altogether 13 numbers of teachers, my lord. They are proposes to transfer from mass transfer from the Longling district, my lord. Without
Not mass. You cannot say transfer is a mass transfer. Therefore, there is no mail ID. This has been passed
Yes, ma'am.
general.
Yes, my lord. Thereafter, my lord. My name is at serial number 6, my lord.
Serial number 6.
6,
Okay.
And my lord, this my lord, the process, my lord, was approved without taking approval from the competent authority. Therefore, my lord, in next phase, my lord.
This was stopped. This
Yes,
and this is order is dated 12/7.
12/7, my lord, communication was given to the,
This is issued by
my lord, this
Director Secondary Education.
Yes, my lord, to cancel all the, my lord, proposed transfer, my lord, transfer and posting of teachers and
Thereafter,
thereafter, my lord, even, my lord, without compliance with this order, my lord,
30th July.
my transfer has been, my lord.
Okay,
issued.
let us do one thing. You go to the director. We are staying this operation till a decision is made by the director.
Otherwise, my lord, in my humble submission.
No, see, why I am saying is,
Hello.
since you are relying on that rule, rule 12, you are reading on rule 11, come to rule 12. 12 gives an option for director, because director here it's himself he has state. It is to the state. So we will say that you will go to the, I will record all these things. Okay? Instead of keeping it here pending, because there is an order of director. Heard the learned counsel for the petitioner. You just record Hassan. Learn 6/24. Okay, then title. Peruse the transfer, peruse the Arunachal Pradesh Education Rules 2010 framed by the state in exercise of its power under section 141 of the Arunachal Pradesh Education Act 2010. The said rule, amongst other, deals in chapter 22 regarding transfer and posting, and certain procedures has been laid down there as regards transfer, including the of transfer, comma, mutual transfer, comma, transfer all held ground, etc. Full stop. The state has also notified teachers transfer and posting policy 2019-2020 on 10th of February 2020. The said policy also prescribed certain procedure for transfer. Full stop. Procedure for transfer. Though by now law is well settled that such transfer policy, not regulation, such transfer policy shall not create any right on the employees. However, a state is expected to follow their own policies. The policy under clause 12 has also created a grievance redressal forum. In terms of the aforesaid grievance efforts, a teacher, if any teacher has any grievance or objection against her or his transfer or posting, comma, she/he may submit represent to the competent authority through proper channel. Full stop. Full stop. Therefore, in the considered opinion of this court, in the backdrop of nature of the grievance raised, the said authority shall be the competent authority to decide the grievance of the petition. Full stop. Therefore, it is this writ petition is disposed of to the, who will decide this, director?
Malad, that the director elementary, although it is not made a part of it.
Okay, director elementary
Education.
education shall, provided that the petitioner may file a representation before director elementary education, raising his grievances, including his grievance that the transfer order has been passed by an incompetent authority, and not which incompetent authority in terms of clause 11 of the transfer policy, and that even after specific direction of the director of secondary education stalling all transfer orders by its message dated 12/7/2024, the petitioner is sought to be 24, the impugn order dated was issued on 30th of July 2024 by the deputy director. Full stop. The petitioner shall file such representation within 7 days from today before the director elementary education, and on such if such representation is filed within the aforesaid period, comma, the director elementary education shall consider the same and pass a speaking order in terms of extant norms and policy of the state. Full stop. Such exercise be carried out within 2 weeks from the receipt of the representation of the petitioner. Full stop. Till such determination is made by the director elementary education, comma, the impugn transfer order shall remain suspended.
The problem is there. My lord, may come to page 46. My lord. This is
Page-
interim transfer order.
46.
46. This
Ah.
is interim transfer order, my lord, by which I have been transferred, my lord.
Mm.
And thereafter, my lord, 30 July
Mm.
is my lord, follow-up order, my lord, consequential order, subsequent order, by which, my lord, I have been directed to join the school, failing which I shall be invite disciplinary.
Have you joined?
No, man, not joined.
You have not joined.
Yes, my lord.
So you have stayed there.
Lord, yesterday, my lord, I have served with a copy of order, my lord.
Ah.
Here, my lord, my pay has been held up.
Full stop. No, full stop. It is made clear that in view of stay of the order of the order dated 5th of July 2024, all subsequent actions thereto shall also remain suspended till the determination made by the, just you write, you have written till such determination, the impugn dated so and all subsequent action that has been taken shall also remain suspended till such determination.
Okay, deeply, my lord.
Difficult
Yeah, yeah.
on 19th. Difficult. Why I'm finding it difficult. This writ petition, I myself is having a doubt of maintainability itself. You have no grievance.
Absolutely.
You are being paid. How can you have grievance for others who have settled for 30 years? Land acquisition is not in that way. On the prayer of the learned council for the release this matter on 19th of
August.
August.
19 August.
Heard. Will issue a notice at this heard. It's the 14 learned council for the petitioner Also her Swenso for standing counsel, Health Department. The petitioner is a dental surgeon and was recruited on contractual basis after due selection process. Full stop. It is the case of the petitioner that similarly situated person were regularized against sanctioned vacancies in terms of the extent policy and norms of the government,
And as decided by the-
action, policy and rules of the government.
and the decision.
However, the case of the petitioner was not considered even though a vacancy was, there was a vacant post. Full stop. Issue notice returnable on. Returnable after 4 weeks. You accept? You have notice for all as Swenso has accepted notice. No, accepted notice for all the respondents. No formal notice need be issued. However, extra copies of the writ petition
I'll give 2 extra copies.
are in requisite in numbers be furnished to the learned standing council.
Obliged.
Item number 16.
Yes. Who needs to file affidavit?
We have already filed, Your Lordship.
Land management. The land,
No, Your Lordship.
who is land management? You are.
No, Your Lordship.
Who is land management? Will you file or not file?
Standing counsel, just right here,
Okay, on the prayer of the, you are enjoying a stay.
My lord.
On the learned, prayer of the learned council for the land management department, matter stands adjourned to enable the department to file affidavit in opposition. List this matter after 4 weeks. Interim order parts earlier shall continue till the next date of listing. Obliged.
My lordship, here in the case, I am challenging the impute order which by the deputy commissioner.
Readings are complete.
No, my lord, we have to file,
No,
my lord.
I have not been given interim, but what my contention is that this
Are you still there? Have you been evicted?
not yet evicted. It is a cover case. My case is cover case because I have applied for allotment. It seems to
How have seen that you have applied?
2021 and during the pendency of the application.
Hard.
And
It's a
without
party. Learned. We'll give you a protection if you have not been evicted till they file their affidavit. Huh. Hard, Mr. Learned Senior Counsel, assisted by for the petitioner. Full stop. The instant writ petition is filed assailing an eviction order dated
8 July 2024.
8th July 2024, seeking eviction of the petitioner. Full stop. It is the petitioner that
Page 70 is
it
my
is the case of the petitioner that the authorities could not have exercised their jurisdiction under Arunachal Pradesh Public Premises within bracket Eviction of Unauthorized Occupants Act 2003, more particularly for the reason that the application for settlement of the land in question was pending before the competent authority, inasmuch as the petitioner is having a long possession over such land. Full stop. No affidavit has yet been filed by the respondent authorities. Full stop. Considering the right of the petitioner and for protection, more particularly in view of the fact that order dated 8/7/2024 has not yet been executed by evicting the petitioner, as an interim, it is provided that the petitioner shall not be evicted pursuant to order dated 22/5/2024 passed by the additional deputy commissioner state officer and order dated 8/7/2024 issued by the deputy commissioner, capital Itanagar. Full stop. On the next date fixed, affidavit, by the next date fixed, the affidavits may be filed by the respondents, and the respondent, more particularly the deputy commissioner, shall be, learned counsel for the deputy commissioner shall be ready with the record of the proceeding. Authority is deputy commissioner. Now, how can deputy commissioner take an appeal? He will send his additional deputy to pass an order. He will sit as an appellate authority.
Yeah, please, Lordship.
Yes, what is this? Item number?
18, my lord. Contempt notum, my lord.
Yes, respondent. Who is respondent number one? Tell us.
Lordship, I am.
You have entered appearance,
Yes, Lordship.
but it note says that nobody. Have you filed affidavit?
In fact,
And who is respondent number 4?
Lordship, yeah. On behalf of 3, we have filed affidavit and
You have filed affidavit on behalf of
respondent number 3.
3.
So
Who is respondent number 1 and respondent number 4?
Lordship, 4 also we have filed.
4 filed.
Yes, Lordship.
Now, who is 1?
This one also probably we have filed, Lordship.
Filed.
Yes, Lordship.
So there is a wrong appeal note. So therefore, yes, what to be done? Though office note dated 31/8/2022 reflects that AD card of respondent number 1 is returned back. Okay, duly though office note dated 31/8/2022 reflects that service report in respect of respondent number 4 is still awaited. However, it is submitted by who will repeat the report? Mr. Apang Larned Senior Counsel. It is submitted to Mr. Apang Larned Senior Counsel that he is representing the respondent number 4. In view of the matter, the service is complete. Service is complete. Yes, list this matter when?
Anytime.
After 2 weeks.
After 3 weeks, my lord.
After 3 weeks. Affidavit file, you have filed reply?
No, my lord.
You want to file? In the meantime, the petitioner may respond to the affidavits filed by the respondents if so. Okay.
Made, Lordship.
Yes.
My lord, this is an amendment petition, my lord. So,
Amendment?
Yes.
What amendment?
For amendment cause list, cause title, my lord. So respondent number 5 and 4 and 5 have been incorporated.
Okay. Where is that order?
Annexure A.
Earlier order?
Annexure 8 for page 14. 14 to operative portion is my lord, 17 and 18.
There are three. Accordingly, the learned counsel for the petitioner prays for and is granted liberty to amend.
No IA is required. You go and give a cost title to the registry with a copy to them. Now registry will remove the
They want order, my lord, this court.
what order? There is already an order. See, according to learned counsel, amended cost title to be incorporated, to submitted to whom? To the registry.
Registry, yes.
Full stop. This court, okay, this is an application seeking permission to amend, to furnish the amended cost title in terms of this court's order
27. my lord.
dated 27/5/2024, passed in IA 12 of 2024. Full stop. By the aforesaid order, this court allowed amendment of cost title and directed the petitioner to submit amended cost title to be incorporated in the writ petition. Such order really mean submission of the amended cost title before the registry and to the respondent counsel so that the earlier cost title can be removed and the amended cost title be inserted in the writ petition. Full stop. Accordingly, it is clarified that no separate application, the present one, is necessary inasmuch as earlier order dated 27/5/2024 clarifies the aforesaid position. Accordingly, the present application stands closed. The petitioner shall furnish a copy of the amended cost title before the competent section of the registry, who shall in turn incorporate the same in the pending writ petition, and copies of such amended cost title also be given to the learned counsel representing all the respondents so that they can also amend the writ petitions accordingly. Copy of the writ petitions served to them accordingly. IA stands disposed of. Yes.
Your Lordship,
File.
unless my, Your Lordship, a prayer. Your Lordship, I want to withdraw the petition number 320. Item number 8. Maybe give a liberty to file it fresh.
Okay, learned counsel for the petitioner submits that he may be allowed to withdraw this writ petition with a liberty to file a fresh petition. Full stop. Prayer is allowed. Accordingly, the present writ petition shall be dismissed on withdrawal with a liberty as prayed for.
Please.
Yes, what is this?
Your Lordship, this matter arises from impugn order dated 9/12/2023.
Where is that?
This is the award of Lok Adalat,
Where is that source?
Your Lordship.
So as
It's in page number 35.
yes, you're present.
Here it's written it's present, but he was not actually the complainant and the petitioner in this writ petition have been involved in one agreement. That is,
That we understand, but your whole case was that you are not present, but it is recorded you were present.
yes, it's present, but there are some other facts which I would like to.
What are the other facts?
Actually, it's in the para 4 of the petition. On 5th May 2022, the petitioner and the complainant in that order were engaged in one agreement where they have executed for actually orally the petitioner who is illiterate. Petitioner is the illiterate, and they have agreed for 25 lakhs of one money borrowing, and in the agreement they have written 50 lakhs, but the petitioner couldn't read because
Learned counsel for the petitioner. By the present writ petition, an order dated order dated 9/12, huh?
1912,
9/12,
9/12, 2020.
9/12/2023, whereby an award was passed in CR case number 03 of 2023. CR case is negotiable instrument.
Yes, Your Lordship.
How that should not be your ground. Your ground should be something different. It is the contention of the petitioner that the aforesaid order is a result of fraud, inasmuch as in a case under Negotiable Instrument Act, a direction has been issued by the Loco Adalat to transfer a landed property in lieu of non-payment of the loan amount. Full stop. According to the learned counsel for the petitioner, such course of action is not permissible in a Loco Adalat. Inasmuch as a fraud has been played upon the petitioner. Full stop. This matter needs further.
Your Lordship, here the member is also the this complainant's counsel in the lower court. That is the matter. Here the
It is also her case that the member of the Loco Adalat is the counsel.
One of the members, one of the
One of the member of the Loco Adalat is also the counsel representing the complainant in CR case number 03 of 2023. Full stop. This matter needs further consideration. Accordingly, let a notice be issued returnable after 4 weeks.
Your Lordship, interim may be given.
Who will appear for whom?
I'm appearing for 1 to 3, my lord.
Swenso accepts notice on behalf of respondent number 1, 2, and 3. Therefore, no formal notice is to the seat respondents. However, extra copies of the petition be furnished to the learned council representing such respondents. First up, notice to respondent number. Other respondents
4, my lord. Only one, more, 4.
be issued through registered post as well as by usual process. Full stop. Petitioner to take steps for issuance of such notice within a period of 5 days from today. Full stop. Considering the nature of allegation, the impugned order dated 9/12/2023 passed by the Local Adalat in connection with CR 03 passed by the Local Adalat consisting of Local Adalat in connection with CR case number 03 of 2023 shall remain suspended.
May I please, you know?
Yes.
My lord, this is a transfer matter, my lord. I'm challenging the impugned transfer order dated 7/8/2023, my lord, which my lord will find at page 18, my lord. My lord, this order has been passed in contravention to the guidelines issued by the government of Arunachal Pradesh, my lord. Whereby the normal tenure of an officer and staff is 2 years, my lord. But I am yet to complete my tenure at my present place of posting.
But there is no right to continue.
But then, my lord, there is a guidelines, my lord, which has been issued by
Where is the policy?
at
There is
page,
no right.
at page 22, my lord.
Okay. Heard the learned council for the. We are taking this matter on Monday.
I'll put a caveat.
Monday, the PW will produce the record. We'll decide on that matter itself. We'll see the record, whether public interest or Melafide or whatsoever. We'll decide on that.
My lord, on Monday, I'll be out of the session
Tuesday.
till 14.
Or otherwise,
Well,
Tuesday.
Yeah, submit one representation. Let the representation be considered. Otherwise,
But
since
we'll see, representation will consider same fate will happen because his allegation is the MLA.
otherwise MLA's allegation, this court has
MLA is also no quarrel. And nowadays,
yeah.
local MLA can also do
Yeah.
law is well settled. So therefore, we wanted to see the record on Tuesday. It is an order of 7th. She will also not suffer if we stay for these 2 days.
I have already been
They have already joined or released.
Release and.
Release and join, my lord.
She also joined.
Well, I have not been released, my lord. But then the order was on, impugned order was on 7th. She was released on 8 and she joined on.
Very good.
Very fun.
Very good. So, when Tuesday? Tuesday will examine.
On 16th, my lord. 16th. I have some difficulties.
You are not available
Yes, I will not available.
till 15th or what?
Till 14, I will not available.
So you will be back on 16th.
15, I will back evening. 16, I'll be there.
See, if she has joined, it will be difficult to pass an
Yes.
interim order. So therefore,
But
what
then-
we can do is we can decide on 16th itself. If there is
Yes.
any material, we see the
Yes.
transfer order, no affidavit is required to file.
Yes.
We'll see the record. If the grounds are satisfied, Melafide, this, that will, but you should be aware that that transfer guidelines are will not create any right so as to. That is well settled and division bench judgments are there, Supreme Court judgments are there.
At least, since there is a guideline, my lord, at least let me complete my tenure. There is.
No, that we cannot say.
Yes.
That direction we cannot issue. That is the
And-
settled law.
My lord, the sequence of the events.
Okay, the present petition is filed assailing an order dated 7/8/2024, whereby the petitioner was transferred from Laying Yangte to Loing Yangte as executive engineer,
Yes.
executive engineer, comma, RWC 0, full stop. It is MS and again learned counsel appears on behalf of the respondent number 3 on caveat. Full stop. Caveat stands discharged. Full stop. The learned counsel the learned counsel for the respondent number 3 submits that she was already released and joined in the place of posting. In view of the aforesaid, let this matter be listed on 16th as in the motion column itself, on which date the learned standing counsel for RWD shall produce the record pertaining to the transfer and posting under challenge, inasmuch as an allegation of influence of the local MLA 21 Koloriang Assembly has been made. Full stop. List accordingly.
Till the time, my lord.
What till then? Then it will create a problem for her also, you also. Both will be hanging. Now you are hanging.
Obliged, ma'am.